The position with South Africa is that we obviously need to address the backlog and the delay that is caused in the prosecution of claims generally, not just commercial court matters. And I think all of these alternative dispute resolution proposals will obviously assist us in dealing with those issues. Of course, we recently established that there's a 4-year, 5-year delay in getting allocated a trial date in civil matters. And this fits in with what our JP had in mind when he introduced mandatory mediation before you get allocated a trial date. So just from that point of view, not just specifically to commercial court matters, but also to matters generally, I think that may very well come in handy at a time when we need to find ways of reducing the number of outstanding cases.
I personally have not seen that, because as I see it, the way practitioners behave in court, if you treat practitioners with respect, they tend to give it back that respect, even more than you have to them. So as a consequence, in my court, the way I manage my court is in such a way that is not, the bullying is not even given a chance to rear its ugly head. So personally, I've had a very good working relationship with counsel, even to a point where the court does not agree with what they say. But the whole issue of respect, the whole issue of collegiality between the court and counsel, it's in my own personal observation, has been quite good. And I have not experienced it as yet. Perhaps it's a function of me not having done it for 20 years or so, like some of my colleagues that were speaking in the discussions. But just a little comment on what my brother just said regarding fast-tracking cases. In our situation, especially with regards to the commercial matters, we tend to, as part of the judicial management,
it should be to the legislature more than the courts, because the legislation is to be drafted such that the courts are able to dispense justice. ADR is very important. As my brothers have already said, it curtails the time taken to get to the finality of the case. More especially when it comes to business. I mean, every litigant has a right to have his or her matter decided speedily. But now we are looking at the business or commercial matters, whereby you find that economic development is involved, employment opportunities are getting lost because litigants are waiting in the queue. So I believe that it is time that ADR should not be an option. It should be used as a matter of must.
I think that there's always been a very cordial, at the very least, relationship between our two countries and our two governments. I think we have mutual business relationships. Some of our South African companies are based here, not based here, they operate here, and they've been well received, and they're treated well in Uganda. And as a South African and as a nation, we appreciate the hospitality and the cordiality of the Ugandan people and the Ugandan government in receiving South Africa and our companies in the way they've done. We also know that there are many Ugandans studying and living in South Africa, and we hope that we reciprocating by treating them as